Welcome to this explainer. Look, if you've been navigating the complex architecture of South African law, you already know that transitioning from the objective act, the wrongfulness, to the subjective blameworthiness of the actor is where things get really fascinating. Our absolute focus today is comprehensive mastery of this chapter. By the end of our time together, you're going to have a rock-solid, practical grasp of exactly how fault and accountability operate in delictual liability. Here is our roadmap for today. We'll start with the gateway of accountability, then branch out into the two paths of intent versus negligence. From there, we'll unpack the Dolus eventualis dilemma, dive into the reasonable person standard, explore contributory fault, and finally, lock it all in with some crucial landmark cases. All right, part one, gateway to fault, accountability.
Okay, so fault is your general prerequisite for liability, right? But accountability, or toerekeningsvatbaarheid in Afrikaans, is the absolute prerequisite for fault. You literally cannot be negligent or intentional if you lack this basic capacity at the exact moment of the act. And it requires two very distinct mental abilities. First, the cognitive capacity to actually distinguish right from wrong, and second, the volitional capacity to act in accordance with that appreciation. If either of those is missing, the whole framework collapses and the law simply cannot attribute blame.
Now, the law treats specific factors that impact this capacity in some really fascinating ways. Take youth, for example. Kids under 7 are never accountable, and those between 7 and 14 are presumed unaccountable, though you can rebut that. Severe mental illness obviously excludes capacity if it completely wrecks cognition or volition. But intoxication, that is a classic legal trapdoor. A person might be entirely will-less and totally lack accountability at the moment they crash their car, but they are still on the hook. Why? Because their accountability existed earlier, back when they made the voluntary choice to consume alcohol. It's called actio, libera, and causa, and the law traces liability right back to that initial choice. Moving on to part two, the two paths, intent versus negligence. You might be wondering, why does differentiating between these two even matter? Well, it fundamentally changes your legal outcome. If you are claiming for injured feelings, the actio injuriatum, you generally have to prove actual intent. Negligence is really only enough if we're talking about patrimonial loss. Plus, you can actually write a contract to exclude liability for negligence, but public policy completely forbids you from contracting your way out of intentional harm. And, as we saw in the SV Nyubane case, intent is such an extreme departure from the reasonable person standard that if you act intentionally, the plaintiff's own contributory negligence usually goes right out the window. You bear the full blame. Let's step down the ladder of intent, or dolus. At the very top, we have direct intent. Super straightforward. The actor desires a specific harmful consequence, and that's their primary aim. Step down one rung to indirect intent. They want one thing, but they know a harmful consequence is an absolute unavoidable byproduct. But then we hit the bottom rung, dolus eventualis. This is where things get heavily litigated. The actor doesn't actually desire the bad result, but they subjectively foresee that it's possible, and they reconcile themselves to it. They basically say, whatever, and proceed anyway. Which brings us nicely to part three, the Dolus eventualis dilemma. This is a ridiculously thin, fact-intensive line, but it is absolutely crucial for your mastery of this topic. We have dolus eventualis, which is intent, versus luxuria, which is conscious negligence. In both situations, the actor has actual subjective foresight that harm is possible. So what's the difference? It all comes down to their internal attitude toward that risk. In dolus eventualis, they reconcile themselves to it. They accept the risk as part of the bargain. In luxuria, they foolishly and unreasonably convince themselves the harm won't actually happen. They don't accept the risk, they just terribly misjudge it. One makes you an intentional wrongdoer, and the other just makes you incredibly careless. Let's shift gears to part four, negligence and the reasonable person. To really nail this legal architecture, the authoritative Kruger v. Quitzy test needs to be your absolute best friend. Forget what the defendant actually thought subjectively. Negligence is measured objectively against the bonus paterfamilias, the reasonable person. Now, this hypothetical person isn't some timorous faint-heart who is terrified of their own shadow, right? They're just a person of ordinary intelligence with a basic knowledge of everyday dangers like fire or electricity. So, we ask, would this reasonable person foresee the harm? Would they take steps to guard against it? And did our defendant fail to do exactly that? But how do we even determine what was foreseeable in the first place? Well, South African courts strongly prefer a concrete approach. They don't just ask if harm of some vague kind was foreseeable in general. They want to know, was this specific harm occurring in this specific manner foreseeable to the reasonable person. It grounds that objective test in the gritty reality of the actual incident. So if we decide that yes, the specific harm was foreseeable, we move to step 2 of Kruger v. Coetzee. Would the reasonable person have actually taken steps to prevent it? To figure that out, courts balance 4 preventability factors. First, the degree of risk. Was it a 1 in a million freak accident or highly likely? Second, the seriousness of the harm. Are we talking about a scratched bumper or a fatal injury? Third, the utility of the conduct. Was the defendant speeding just for fun, or were they driving a rushing ambulance? And fourth, the burden of prevention. How expensive or difficult would it have been to just stop the harm from happening? Balancing those 4 gives us our answer.
Okay, part 5, modifiers, contributory and gross faults.
What happens when it's a mess and both parties are actually to blame? This is handled by the Apportionment of Damages Act of 1956. And these 2 modifiers function very differently. Contributory negligence just means the plaintiff was also careless. The court assigns a percentage to their fault, say 30%, and literally just reduces their damages payout by that amount. But contributory intent, that's the assumption of risk. If a plaintiff willfully and unreasonably exposes themselves to a known danger, the court can treat that as a complete defense. It entirely cancels out the defendant's liability, zeroing out the payout completely. We also have to keep an eye out for gross negligence. As defined in the M.V. Stilatingus case, this is not your run-of-the-mill carelessness. It is a marked extreme departure from the norm, where the actors show zero consideration for the consequences. And this is huge, because courts heavily scrutinize any contract clause that tries to exclude gross negligence. Oh, and a quick self-correction, or rather a clarification to make sure you master this. You can't have a negligent omission without a wrongful omission. Doing nothing is only negligent if you had a pre-existing legal duty to act in the first place. Finally, part 6, applying the law through a couple of landmark cases. Let's look at Escom Holdings v. Hendricks. An 11-year-old child climbed an electricity pylon and suffered a terrible electrocution. The court had no problem holding Escom negligent for leaving it unsecured. But the fascinating part is how they handle the child's contributory negligence. They didn't just slap a purely objective, reasonable person standard on the kid. Instead, they handled his youth right at the accountability phase. They asked subjectively, did this specific 11-year-old have the maturity to appreciate that danger? It is a perfect example of why accountability is a totally distinct gateway inquiry. Then we have the legendary Carmache case. It's famous for wrongfulness, sure, but its impact on fault is massive. The police and prosecutors failed to oppose bail for a known dangerous criminal who then attacked the plaintiff. The Constitutional Court came in and completely transformed the negligence inquiry. They ruled that the objective, reasonable person standard doesn't just exist in a vacuum anymore. It has to be infused with constitutional norms and values, things like dignity, freedom, and security. What we consider reasonable is forever tied to the Constitution. So, as a final synthesis, here is your ultimate cheat sheet for mastering any fact pattern. Always follow this exact architecture. Step 1, is the defendant accountable? That is your gateway. Never skip it. Step 2, did they act with intent or negligence? Step 3, if it's negligence, deploy that Kruger v. Coetzee test and those 4 preventability factors. And step 4, check for contributory fault. If you internalize this sequence, I promise you, you'll navigate any delictual liability scenario flawlessly. I want to leave you with this thought as we wrap up. Carmichael proved that the reasonable person standard isn't just frozen in time. So, as society and our constitutional norms inevitably evolve in the years to come, how are the fundamental rights of tomorrow going to reshape what we currently accept as reasonable behavior today? It's proof that the law of Delict isn't just a dusty set of rules. It's a living, breathing framework. Thanks for joining me on this explainer, and keep questioning those standards.